Alright, Presidential Transition Guide for Federal Human Resource Management Matters Election Year 2024 Updated Guidance Incoming Second Term and Administration Agency Officials who have transition responsibilities. Office of Personnel Management, December 2024. Contents, Standard Ethical Conduct Overview, Transition Issues. Position individual subject to change in transition overview, transition issues, involuntary separations and resignations, appointments, presidential appointments, senior executive service appointments, transition issues, senior executive services, expected service equipment, so expected service appointments, compensation pay rates, limited pay, flexibility, reemployed, annuities, leave, separation payments, retirement, health, life insurance, other benefits, unemployment compensation, dislocated worker services, personal security vetting between election inauguration, after inauguration, post-inauguration vetting process per appointment time, reciprocity, continuous vetting, personal identification verification overview, personal identification verification, credential transition team members, appendixes, question answer, separation, political appointees award for during 2024 presidential election period. C, sample separation notice. D, question answer federal benefits, new political appointees. Appendix E, merit system principle, prohibited personal practices. This guide provides an incoming second term administration agency officials who have transition responsible for the detailed description, various rules, regulations, policy governing the establishment, the transition team for the departure of the appointment of the political appointments, and the treatment of the career of federal employees, especially members of senior executive services during the transition period. 1. Standards of ethical conduct. The section provides general guidance for the contact lobbyists seeking work outside federal government, post-employment restriction, protection of federal records for the unauthorized removal. For answers specific to the question, guidance should be sought for the agency ethics officials. Overview. All executive branch employees are subject to the standards of the Ethics Code of the employees of the executive branch. Title 5, Part 2635. The standard includes 14 basic principles of ethical conduct, provide uniform rules about gifts and outside sources of gifts between employees, conflicting financial interests, impartiality, performing official duties, seeking other employment, and misuse of the position, outside activities. Some employees are subject to supplemental regulations prohibited and promulgated by the agencies. H, agency is responsible for the administration agency of the ethics program for appointing designated agency ethics official, the alternative designated agency of ethics official who, along with supporting an ethics official for the administrative of the agency's ethics program. The agency ethics program is generally responsible for the following: providing counseling and advisory services, providing ethics education training programs, reviewing financial disclosure reports, monitoring administrative action, sanctions for the ethical violations, communicating with the Office of the Government of Ethics. The Office of Government Ethics provides overall policy leadership of the executive branch, departments, agency, Office of the Government Ethics review public financial disclosure reports. The executive branch presidential appointees require Senate confirmation of certain White House officials to determine whether any of the entries on the forms may give the rise of the potential actual violation of applicable law or regulations recommended with appropriate corrective action. Office of Government Ethics also provides advice to other ethics of the matters of the presidential appointments, senior executive services appointees. Schedule C employees. Schedule C employees are those who are expected to competitive with the service because they occupy positions that are exclusively associated with a non-career political appointment that is identified by its close working relationship with the president, head agency with the other key appointed offices who are responsible for furthering goaling policy of the president of the administration to carry out no expectations continued employment beyond the presidential administration during the appointment occurred. Transition issues. Lobbying Disclosure Act. Lobbying Disclosure Act, Public Law 10465, Title 2, United States Code, Chapter 26, Sequence 6001, Intent Sequence impose disclosure registration requirements for the lobbyists who contact covered with the legislative executive branch official that requires for the covered executive branch official with its contact or lobby disclosure of the fact that he or she was covered with the executive branch official upon the request of a person making lobbying contact. Covered executive branch officers are the president, the vice president, any officer with any other individual functioning in the capacity of such officer, employee, or executive officer of the president. Any officer employing serving in position level 1, 2, 3, 4, and 5 of the executive schedule as designated by statute executive order is a member uniform service whose pay of the grade is above the 0 to 7 under Title 37 United States Code 201. Any officer employing serving in the position confidential policy, determining policy, making policy, advocating charter described in Title 5 U.S. Standard Code 75 and 11B2B. General Act applies to presidential appointment requiring Senate confirmation. PAS. Schedule C does not apply with the members of senior executive services unless they meet with the criteria in C or D above. If you have any questions or concern with the lobbyists, you have to respond with the contact lobbyists who are what your responsibilities are and act and should contact any agency, general counsel, federal employees seeking non-federal employment. Pursuant to Title 18 United States Code 208, the executive branch employees generally prohibited for the performing work in the government jobs on matter that would affect the financial interests of someone that which would negotiate with the employment standard of the ethic of the conduct of the executive branch. Title 5 CFR Part 2635 have similar rules that apply before the back. Further negotiations begin may apply when an employee only is sent with a resume prospective of employer participation. Such procurement matters are subject to employees to additional requirements relating to private employment contracts. In accordance with the job trading on the congressional knowledge of the 2012 Stock Act, an employee who is required to file a public financial disclosure report must sign with a notification statement with his or her agency ethics official within 3 business days of commencing negotiation entering into the agreement with non-federal entity except for the post-government employee with the compensation of the statement that must identify with the entity specify the date with the negotiation agreement commenced, so the public filer must open the document with his or her qualification for any of the particular matter we have the right predictable effect of the financial interest that neither submit with a signed disqualification document to his or her agency's official. Employees should be careful not to misuse the government resource such official time and service of the employee equipment supply with restricted information connection with the job seeking. After the employee has accepted the job outside of the government, he or she must continue to refrain from working on matters in his or her government job that would affect the financial interest future of the employer. If agencies offers outplacement services to all of the employees departing with the non-career employees may use these services. However, the agency may not establish outplacement services for the non-career employment employees only. See Appendix A with the question 6 for the additional information. Post-employment restriction. There are certain restrictions on employment with the separation from the government service. Of the general, these restrictions apply with the representational activity for their application varies depending on the employee's duties, level of authority. Title 18 U.S. Standard Code 207. Additional restrictions were imposed with Executive Order 1398-9. Information on these restrictions must access the Office of Government Ethics website, would include the frequently asked question post-employment under the Ethics Pledge, but agency ethics officials are also available to provide more specific advice with the post-employment restriction before and after its government service. Protecting federal records of the unauthorized removal. The National Archive of the Record Administration constantly reminds the heads of the federal agency with official records must remain in the custody of the agency. Federal officials should be aware of the criminal penalty of the unlawful removal or destruction of federal records. Title 18 United States Code 2071, unless unlawful disclosure of the national security information. Title 8 United States Code 793, 794, 798. Departing on the federal official should contact the agency or records over the question about the maintaining disposal of the record, extra copies of the record. Agency records officers should have documenting your public service the guidance for the agency employee with the management of federal records, including email account for the protection of federal record for the unauthorized removable. 2. National Archive of Record Administration. Publications that draft the records concerned with the maintenance procedure to distinguish between records, personal documentary materials, National Archive and Records Administration records management regulation that draft the identification protection of federal records and also accessible to Title 36 CFR Chapter 12 Subchapter B. 2. Position individual subject to change and transition. This section provides an overview on the position subject to change assigned with the federal employee and transition team, providing continue with the key operation through overlapping assignment separated political appointments. In May 24, 2024, memorandum of the head of the department and agency of the director of the Office of Personnel Management asked the agency to review all personnel action to make sure that they meet the requirements of civil service laws, rules, regulation, and free impropriety. Director reminds the agency of the obligation to undertake the personal action in the manner that conforms fully to the merit system principles and does not involve prohibited personal practices. Overview. Position of the generally subject to change during the transition listed in the document of United States government policy supporting position commonly known as the Plum Book. The Office of Personnel Management prepared for the document every 4 years on request of the Congress. However, in 2022, the periodic listing updated the management to the Management Plum Act, codified in Title 5 U.S. Standard Code 3330F. Mandated in Plum Book, sunsets the final publication of 2024 Plum Act with the mandate of the Office of Personnel Management establish a host, maintain public-facing website containing information on the policy supporting position defined in Title 5 U.S. Standard Code 3330 FA 5. For setting an administration, each subsequent administration, office management, personal management, plum reporting website. There are 4 broad categories of individual positions that may be changed during a transition. Presidential appointments may be divided with consent of the Senate to position the incumbent services pleasure of the President. Other presidential appointments to position and with the incumbent serve as pleasure to the President. Non-career senior executive services appointments and appointments of the other positions which incumbents serve with the pleasure of the agency head. These positions, commonly known as Schedule C positions, are expected to be competitive, serve the rules office personal management based on the character exclusively associated non-career political appointment that is identified by its close relationship with the President, head of the agency, or other key appointed officials responsible for furthering goals and policy of the President and administration carries no expectation of continued employment beyond presidential administration during the appointment have occurred. Position in 4 categories, normally the cabinet office heads for the other executive branch agencies, undersecretaries, assistant secretaries, director of bureaus, and serve as chairmen, members of boards, commissions, and committees. Incompetent, most of these positions customarily resign with a request for the new incumbent administration before the new agency head takes office. Also common for the incoming administration to ask certain persons to remain in their jobs during the transition to ensure that continuing during the initial period of staffing. Transition issue the detail of the transition teams of the Presidential Transition Act of 1963, amended with the establishment transmission team with the federal entity to provide with the orderly transfer of the power between administration Title 30, United States Code 102, note with additional providing with the transition team may hire its own staff of the Act, provided with a detailed federal employee transition team after the November election followed. An employee agency, any of the branches of the government may detail the officer staff of the President-elect with the Vice President-elect. Employee must be the detail of the reimbursement base for the detail must be within consent with the legending agency head with the October 24th. Use of Special Counsel OSC issued the Hatch Act advisory opinion regarding service on the Presidential Transition Team. Overlapping key positions. Agencies cannot employ 2 individuals in the same position at the same time. Dual incumbency, however, to provide continue with a key position meet over the transition needs of the agencies can use the following options. When incumbent intention for the leave have been documented, an agency may establish different position to employ with a designated successor brief period depending on the incumbent departure. For example, when an officer director is leaving, the agency may establish a temporary special assistant position for the short period of facilitating orientation with the incoming director of the Office of the Operations. Office of Personal Management may authorize the use of senior executive services limited appointment authorities for short periods of time, temporary executive positions, Title 5 CFR 317-601C2. Agencies may establish temporary transitional Schedule C positions for similar non-executive positions to help with the transition, Title 5 CFR 213-3302. Involuntary separations and resignations. When the President accepts the resignation, presidential appointed policy-making officer for the separations, involuntary separations, involuntary anytime the resignation submitted accepted whether or not is related to change of the presidential administration. Further, the President has accepted the resignation, presidential appointment, or resignation, non-career senior executive service Schedule C employees who work with the President appointment is involuntary for the purpose of retirement. Agency should include the documentation of retirement application that the President has accepted the resignation of the appointee or the personal appointment with a non-career with a senior executive service Schedule C appointment he works since leaving. Requested resignation. When agency separates an employee who submitted the resignation responsible for the request of the recognized representative of the new presidential administration of the separation voluntary retirement person. The representative must have the authority to request the employee's resignation. The resignation must be requested especially for that employee. Agency should attach the copy of the request from resignation, individual retirement application, and solicited relationship, i.e. the base for the anticipated request for the resignation thus prompted by personal choice voluntary retirement purposes. Caution about separation. For legal reason, notice of the dismissal should avoid tone that implicates any way of the employee reputation. Agency should consult with the General Counsel, legal office of the guns for these areas, appendix C with a sample separation notice. 3. Appointments. The section provided a discussion presidential appointment, senior executive service appointments with expected service presidential appointments, overview, officer for the employees who serve with the pleasure for the President of the author appointing officials may be asked to resign with them may be dismissed anytime they are not covered with standard civil service removal. The procedure they generally have no right to appeal for the termination if they are alleging that such action was taken prohibited discriminatory reasons. The agency should consult with the General Counsel assistance in this area. The certain cases of the statute creating with a position provided the individual appointed by the President may be removed, only for the cause and the end of the statutory term of the appointment. The provisions are found most commonly with the statutes establishing quasi-judicial entities or independent regulatory agencies. Individual position statutory terms can continue with the position until the end of the term unless they resign with a personal reason that are removed from cause. This issue is discussed on such cases as Myers versus U.S. and 272 U.S. 52, 1926, Humphrey, executor of the U.S. 295 U.S. 602, 1935, and Wiener versus U.S. 357 U.S. 349, 1958, Buckley Valeo 424 U.S. 1, 1976. Because of the matters implicated with complex legal issues, the agency shall consult with the General Counsel of the system within the area. Vacancy Act supplementally amended with the 1998 with the Federal Vacancy Reform Act of 1998. The Federal Vacancy Reform Act, or Act, Public Law 105-277 of Section 151, Federal Vacancy Reform Act, codified with the Title 5 U.S. Standard Code 3345 through 3349D, prescribes requirement temporary filling vacancy with the required with the file with the presidential appointment over the Senate confirmation appointments. Presidential appointments of the Federal Vacancy Reform Act is amendment provides rules of the temporary filling out of the presidential appointment Senate positions, and in most cases the Act exclusively means filling vacant presidential appointment Senate positions with the person designated as an acting official of the Act. However, it also recognizes other limited means for the presidential to fill presidential appointed Senate positions with the recess appointment, the provision, or other statutory authorities applicable to a particular agency. The Federal Vacancy Reform Act specifically provides agency head general authority to delegate and reassign the duties within the agency does not remain viable. Specifically, separate authority to filing a vacant presidential appointment Senate position for the temporary basis. An officer becomes vacant when the incumbent with the dies resign with the otherwise unable to perform the function duties of the office. The Federal Vacancy Reform Act does not specify the full range of the circumstances with the constitutional inability, but legislative history indicates that it would become incompetent being fired in prison, suffering a serious illness. The Act specifies the expiration term of the office of the constitute with the ability to perform function of the duties of the office. If under the Federal Vacant Reform Act, for the generally three categories of person who can serve in an acting capacity, vacant presidential appointment Senate positions. First, Assistant Vacant Position Act does not define the term, but with the legislative history indicated the general refers to the top deputy with a position. An existing presidential appointment serves Senate from the agency issued from any other agency designated by the president only by the president. Certain senior agencies employees designated by the president only with the president. Specified with the time frame with the other authorities. Statutory consideration limited service of three categories general limited to 210 days with the serving acting with the president appointment silence capacity. Title 5 U.S. Standard Code 3346. Respect to any vacancy that exists during the 60-day period beginning with the presidential inauguration. The 210 days beginning later with the 90 days after the inauguration and the 90 days after the day of the vacancy. The different rules apply with the presidential nominees. As person fills the presidential appointment Senate position with a permanent basis during the period where the position is held with another person acting on a basis. The Office of Legal Counsel of the Department of Justice has extended the guidance of the Federal Vacant Reform Act, which can be found with justice.gov, calling 202-514-2051. The Assistant Presidential President of Presidential Personnel coordinates all activities relating to presidential appointments. Effective date of the presidential appointment Senate of the appointment of the presidential appointment subject to sign with confirmation effective at the time of the date of the president signed with the commission document. However, the individual payment does not begin with the appointment. It is sworn in or signs with the oath of office. For the individual serving with the term of the presidential appointment Senate confirmation term begins with the effective date of the appointment, the day of the president signed with the commission document. Office of Management, Personal Management, contact Angela Champion 202-936-0631, pay and leave. Individuals appointed by the President of the Senate confirmation occupy the position they are paid for the executive schedule of office and pay rates equivalent to the executive schedule. The schedule has 5 levels, level 1 highest, level 5 the lowest. In 2024, annual pay rate for the executive schedule level of $246,400, level 2, $221,900, level 3, $204,000, level 4, $191,900, and level 5, $180,000. Locality pay does not apply with the executive schedule. Note the pay freeze with a certain senior political official with the effect of the pay raise for the Section 4 for the compensation. More information about the pay freeze. Individual executive branch were appointed with the president in the position with the executive schedule but did not cover the leave system. They did not earn annual sick leave, therefore are not charged with leave for absence of work. Senior executive service appointments. Office Management, Personal Management, contact Angela Champion Champion 202-936-0631. Subsection provides overview, career, non-career, service executive, senior services with the key of the transition issue depending on the process of senior executive service selection during the change of the agency head of the 120 days monetary involuntary senior executive services reassignment during the period. Overview of the senior executive service unique executive personal system that includes but most of the top managerial supervisory policy positions of the exclusive branch that are not required for the field for the presidential appointment of Senate confirmation. Senior executive service positions every 2 years of the Office of Personal Management and allocates for each of the agencies specifically the senior executive service based on the agency's need with a numerical allocation. Each agency establishes senior executive service position, designate them either as general or career reserve. The Office of Personal Management assigns to each agency the career reserve floor, which is the minimum number of the career reserve positions that must be established within the agency at all times. Once senior executive serve the position with the designated with the general area of the reserve of the agency, they must obtain with the Office of Personal Management approval to obtain with the designation. See Title 5, see Part 214. General positions may be filled with a career with a non-career limited appointment. Career reserve positions must be filled with career appointing sustained public confidence into the impartiality of the government. Office of Personal Management may make temporary senior executive service allocations available to the individual agencies to help with the transition. Senior executive service non-career appointments. The agencies to make senior executive non-career appointments to any senior service general position without regard to competitive requirements. They also set the pay level of appointments. However, the agency may receive the non-career appointment authority of the Office of Personal Management for making the appointment of White House Office of Presidential Personal holder must have the clearance of the appointment if the appointment takes effect except for the appointment of the senior executive services position. Independent Regulatory Commission is not subject to the review with approval by an officer and with the executive office of the President of the Title 5 U.S. Standard Code 3392D with limited laws for the laws limited to the total number of servants for executive service position that can be filled with a non-career appointment, and 10% of the government senior executive service space allocation, 25% of the individual agency location allocation. Unless the allocation is 3 or less, the additional limitations have been imposed administratively by other statute agency by agency basis of non-career appointment that can be determined at any time with a 1-day notice for the non-career appointment to remove the federal service. It has no right to appeal to Merit System Protection Board, Title 5 U.S. Standard Code 3592, Title 5 CFR Part 359, Subpart 1, Subpart I, a simple separation notice is approved by Appendix C. Senior executive services with limited operation. There are two types of senior executive services: limited operation appointments, limited term, limited emergency. Limited term appointments may be to up to 36 months of the position with the due with the will to expire for 36 months earlier specified time period. Limited term appointments with the temporarily promote the individual continuing senior executive service position. Limited emergency appointment that may be up to 18 months to meet with a bona fide unanticipated urgent need. Limited appointments made only with a senior executive service general position. The individual may not serve with more than 36 or 48-month period. Any combination of limited appointments must meet with the qualification requirement established by the agency. Agencies must obtain the limited appointment authorities of the Office of Personal Management case by case basis with the OPM has provided agency pool of the limited authorities equal to 3% of the total senior executive service position allocation with one authority which is greater. An agency may use the pool to appoint a career type non-senior executive service employee to the position appropriate with a senior executive service limited terms, senior executive service limited emergency appointment without obtaining the Office of Personal Management approval. However, the agency must notify the Office of Personal Management the appointment by entering incumbency information Office of Personal Management Executive Schedule C. With addition, with the help of the transition, OPM may authorize limited term and appointment authority. The individual will have been nominated for the President to have the appointment depending on the Senate confirmation. This limited appointment may not be made with the position where the individual has been nominated. Limited appointments may be determined at any time with a 1-day notice. Limited senior executive service appointments have the removal no right of the MSPM on the termination appointment. The MSP with the Merit System Protection Board on termination of the appointment. See with Title 5 Standard 352, with Title 5 352, 359, Subpart 1. However, the someone limited appointment, the placement right with a position outside of the senior executive service career with the career type of the non-senior executive service employees with the limited appointment, same age as the placement right with his or her former position who is like with the staff of the tenure of the grade of pay. Title 5 Part 317, Subpart F. The individual was covered in Title 5 U.S. Standard Code 7511. Immediately before senior executive limited appointment, they also been entitled with the adverse action procedure for the applicable to the senior executive service with appointment appointments in the event of the removal of proposed based upon conduct, other basis set forth in Title 5, C7, 52, 603, Title 5, CFR Part 75-2, Subpart F of the career and career type of employment, except for the limited employment at another agency near these benefits. Senior Executive Service of the Career Appointments. Career appointments made of either by the Senior Executive Service or the General of the Career Reserve Position. Career appointments with no time limitation provide certain protection. Benefits not covered the non-career limited appointment. Initial career and appointments must be with the competitive Senior Executive Service mayor staffing provision time with the selection of Senior Executive Service filling selection agency. The individual executes the qualification must approve of the Office of Personnel Management Administration Qualification Review Board before the career appointment can be made. The transition issue with the service Senior Executive Services suspension process for the Senior Executive Service candidates in accordance with Title 5 CFR 317-50 the Office of Personnel Management suspending the processing agency of Senior Executive Service Qualification Review Board cover the agency heads of the department announce his or her departure for the time with the provide the income head of the agency with a full opportunity to exercise his or her prerogative. Make it approve the executive restore the decision that will affect the agency performance during his or her tenure with the end of the Office of Personnel Management will impose the monetary with the process of a particular agency. Senior Executive Service Board Qualification Review Board cases will when then headed by the agency department for any of the reason effective immediately upon effective date of his or her department qualification review board monetarily will be imposed at the head of the agency announcement with his or her intentions to leave the office for effectively immediately upon the announcement. Qualification Review Board moratorium is intended to preserve the prerogative of the incoming agency head, but it must be balanced against the need of the continuing agency operation during such transition. Again, according to the Office of Personnel Management, consider the request for the exemption of the agency of the Qualification Review Board moratorium in case-by-case basis. The request for the exemptions should be signed agency head official with a designated act of the agency head absence must specifically address the potential adverse impact of the national security, homeland security, critical agency mission, program or function of the particular Senior Executive Services candidate is not immediately considered for the certification. Monetary for the Senior Executive Services career reassignments. Agency with the may assign with the Senior Executive Service degree of the appointment of the Senior Executive Services position with the agency whichever they are qualified following 15 days advance written note with the reassignment that does not require the geographical move of the consolation with the executive file with the 60 days advance written notice required with the reassignment. That includes geographical move. However, when there is change of the agency political leadership of the law provided with a 120-day moratorium on the individual reassignment with the career of the Senior Executive Service appointment with the career executive that also prepared and serve the new leadership. They also continue with the chain with the fundamental responsible for the Senior Executive. The moratorium was to prevent preemptive of the reassignment by new employees without adequate knowledge of the career executive. The Senior Executive career appointments may not be involuntary reassigned 120 days appointment for the new agency head, including reset of the appointment within 120 days after the appointment of the career appointment is new with the non-career supervisor who has authority to make for the career appointment an initial with the performance of appraisal with the voluntary reassignment during the 120 day period with the permitted with appointment must agree with the written before reassignment. The appointment made new agency head also always start with a 120 day moratorium and another with the official may take with the reassignment of the action with the event with the official head's office for more than 120 days moratorium result of the appointment of the new non-career supervisor agency head to make not the involuntary reassignment of action if the agency has been in office more than 120 days. Designating agency head with the non-career supervisor for the e.g. by the detail of the when the deputy acts on the position is not the same as the making the appointment. Therefore, the statutory moratorium does not come into play with however the agency of the direction may choose to apply with the moratorium in the situation. In this case, the acting with the individual later receive the permanent appointment to the position without breaking in the time of the suspended until the agency imposed with the moratorium counts toward the 120 day moratorium and initiate with the permanent appointment. In calculating a 120-day moratorium and day with not exceeding the 60 during the carrier appointment and serve the detail of the other temporary assignment of the part with the appointment irregular position are not counted. However, the moratorium provides does not restrict the total length of the detail and may exceed 60 days. See Title 5 U.S. Standard Code 39395, Title 5 CFR 317, Subpart I. Career appointments who accept the presidential appointment. The presidential appointment the executive subject is changed with the new administration. However, the Senior Executive Service career appointment was appointed by the presidential service position outside of the service Senior Executive Services without breaking services who have leave of the presidential appointment to review the misconduct, neglect, duty of the maleficiency entitled by the law of the reinstatement of the Senior Executive Services. It does not apply with the former Senior Executive Service career opportunity voluntary move to non-career Senior Executive Service position appointed by someone other than the president or the agency head involuntary with the reinstatement through the direct notification agency. The former career appointment may apply with the office of personnel management up to 90 days after the separation, directed statement. See Title 5 U.S. Standard Code 3593B and Title 5 3177003. Briefing of the new senior executive serve the members of the Personnel Management Center for the Leadership Development offer the day-long orientation session for the new career service executive senior executive service of members of the twice each year. But the session provides execute with an active understanding of administrative goals, priorities, opportunity to gain with a broader perspective of the executive branch for the domestic, economic, foreign policy issues, initiative. Senior executive service members also gave me the information concerning your executive service advised about with the Congress knowledgeable effect of the leadership and strategy, the opportunity for the networking. Expect with the service appointments, office management, personal management, contact Kitakata Floyd 202-606-9531. The expected service includes all position executive branch that has been expected with the competitive service to the senior executive service by statute present in the office personal management Title 5 U.S. Standard Code 2103. Schedule C position. Appointment of Schedule C position expect for the competitive service because they have the policy determining requirements of the required for the incumbent service for the close of the confidential working relationship with the head of the agency, the other key appointed official with the Title 5 CF standard for 213-3301. Appointment of Schedule C position may advance for the approval of the White Office Presidential Personnel Office of Personnel Management. Office of Personnel Management does not review qualifications. Schedule C appointments have final authority over this matter with the possessed of the appointing of the official. Agencies may be separate Schedule C appointments whenever the confidential policy determines the relationship between an incumbent and his or her superior, and for the Schedule C appointment is not covered in the statutory removal of procedure generally has no rights for the appeal of the removal of action of the Merit System Protection Board. This is true regardless of the veteran preference length of the service in the position. Agency should conduct General Counsel's Office of Personnel Management. General Counsel Schedule C separations. Appendix C contains a sample of separation notice establishing regular Schedule C position. Office of Personnel Management authorizes establish each of the Schedule C position revoke the exemption with a competitive service when the position vacancy is vacated with the Title 5 CFR 213-3301. Agency must certify that the position is not created solely but primarily for the purpose of detailing the incumbent over to the White House. A list of Schedule C position published annually with the Federal Register under Part 213 off the Personnel Management Regulation. Presidential can authorize individual exemptions by executive order, such as those listed in Title 5 CFR 68. The temporary transition Schedule C position to help with the transition off of the Personnel Management designated authority to agency to establish a limited number of the temporary transitional Schedule C position Title 5 CFR 213-3302. The agency has the delegated authority during the 1 year period immediately following a change of the presidential administrative of the new department. Agency has entered the duty of the new agency created. The agency make an appointment. The authority with up to 120 days may extend the appointment once up to 120 more days. The agency must notify the Office of Personnel Management working day for the appointment of the temporary transition Schedule C position. Agency must notify the Office of Personnel Management with 3 working days when the position has been vacated. In addition, the agency head of his name must be certified for the position not so created solely primarily for the purpose of the detailing of the incumbent of the White House. Must identify the position incumbent with the agent plan for the convert employee of the temporary transition Schedule C position, non-temporary regular Schedule C appointment with the temporary appointment may be designated with a provisional appointment of the Title 5 CFR 316-403. This permits the agency to treat employee with a non-temporary appointment for the benefit of the purpose of provisional appointment is made under the authority established by law, executive order, regulation granted with the Office of Personnel Management Title 5 CFR 316-403B with the documentation instruction of the Office of Personnel Management Guide Personnel Processing Personal Actions Chapter 11 and expected service appointments available to the Office of Personnel Management website. Briefing the new Schedule C appointments. Historically, the Office of Personnel Management conducts in conjunction with the White House Presidential Office has sponsored one-day briefing of Schedule C with the non-career senior executive service appointees. These briefings provide appointments for the understanding of the President's expectations as a broader perspective of the executive branch initiative provided with the information from the Government Ethics Act and the current domestic economic foreign policy initiatives. Positions expected by statute. The position has been expected by statute include those of Foreign Service, the Department of State, of the Federal Bureau of Investigation, Department of Justice, all of the position of the Tennessee Valley Authority, Government Accountable Office of the U.S. Postal Office, Service of the Medical Employee of the Veteran Health Administration, the Department of Veteran Affairs position, Cyber Security Talent with the Management System, Department of the Homeland Security. Most of the agency positions are under separate merit system or not subject to change during the translation. Over Schedules A, B, and E, in addition to the policy to determine the confidential position described in the preceding section, Congress and the President and the Office of Personnel Management can accept the other positions from the competitive service of the senior executive service of the Office of Personnel Management, except for the position under the Schedule A, B, and D, and E. For variety of reasons, employees in these positions are not subject to change during the transition. Position expected by the President of the Office of Personnel Management in certain circumstances by the President of the Personnel Management, except for the position from the competitive service exemption of the Schedule A, B, and E, D, A, B, D, and E position, Schedule A positions out of the confidential policy determining character, which if not practical, examine an example to include the attorney's individual certain disability short-term positions filed with during an emergency. Schedule B position the other confidential policy to determine character with a non-practical hold competitive examination. Alright, Schedule B position other than those confidential policy to determine the character of the non-practical competitive examination. These appointments shall be each other the non-competitive examination prescribed by the Office of Personnel Management are subject to personal qualifications change with the Office of Personnel Management occupation grade level, for example, the development position associated with the senior executive service candidate development program are included under Schedule B Title 5 21330. 3201. Schedule D positions other than those of the confidential policy to determine the character of the competitive service requirement to make for the impractical adequate recruitment of sufficient numbers of the individual attending qualifying career technical education programs, including the national service participation individual recently completed with a qualifying career technical education program. Schedule D pathway program consists of these programs internship prep of the recent graduate programs and with the Presidential Management Fellows program, example of Order 1356 with the Title 5 2133401. Schedule E position of the administrative law judge. If the administrative law judges are currently employed in 28 federal agencies, adjudicated dispute involved with the various agencies with the administrative, the regulatory problem, the administrative law judge for the responsible for the presiding with the agency, the hearing with the taking evidence of the acting as a finder of the proceedings, as well as acting as decision making, make an initial determination about the resolution of the dispute with the appointment of the administrative law judge is on after July 10th, 2018, or made with the expected service under the schedule Executive Order 1384. 3. Schedules A, B, and D appointments of eligible veteran preference whoever they have at least 1 year qualifying service within the title of the statutory procedural appellate rights if they are removed from the federal service of conduct with their performance. Reasons that in addition to the expected service employees with other preference eligible to receive statutory procedural appellate rights provided that they have completed probation or trial period of initial employment pending conversion to the competitive service that have completed 2 years of qualifying service. Expert counsel and appointments. Office of Personnel Management, Michael Glenn, 202-606-1571. Agencies may appoint expert consultation of the position preliminary required by the performance advisory services rather than performance of the operating functions with regard to the competitive of the civil service requirement of the Title 5 U.S. Standard Code 3109. Agency may be expert with the consult with appointments of the individuals who have been nominated with the President but not yet confirmed. In addition, agencies may have the authority to appoint individuals who are permanent except active with the appointment is pending Title 5 304 103B6. Individual work assignment must comply with the expert with the consolation requirement of Title 5 Part 304. Agencies that may not be used expert consolation appointment to avoid employment to receive the solely anticipation competitive employment. An expert and a consulate and appointment authority may not be used to fill positions senior executive services. Title 5 U.S. Standard Code 3109. However, the position meets the criteria of placement senior executive service. The Office of Personnel Management may authorize limited appointment authority to appointment of the individual during transition period. Expert consolation appointment with the Title 5 U.S. Standard Code 3109 may not be paid more than the daily biweekly rate for GS 15 Step 10, excluding locality pay with any other additional pay. This higher rate especially authorized by the statute Title 5 304 105. They may also reimburse for the travel of the intermittent employee with the not for the moving expense, but may participate with the orientation training program with a government expense. 4. Compensation. Office of Personnel Management contact Carrie Jones pay with Jennifer Melvin leave 202-606-2858 unless otherwise stated. The section provided the information basics hourly level of locality pay with the aggregated pay with the limited pay flexibility available to address staffing difficulty pay for re-employed annuities leave of the pay with the separation from the government. Note that the pay leave of the provision review for the section authorized under Title 5 United States Code which apply with the most of the federal employees have with the federal employees certain agencies that are not covered in Title 5 pay and leave provisions. Such agencies are responsible to inform effective effective employees regarding the pay and their leave benefits, pay and rate limits, pay and free senior political appointments of the further consideration operation after the 2024 continue with the provision of the continue with the free for the payable pay rates of the vice president certain senior political appointment during the calendar year 2024, section 747 Title 7 Division B of the Act. See Appendix OPM Guidance Memorandum CPM 2024-09 on the CHCO website with the official with the statutory rates for the pay with the vice president and executive schedule positions are not affected by the freeze. These official rates are used to determine the rate of range of the aggregate of the pay limitation employed with the pay system without unaffected with the pay free for the future congressional action will be determined whether the pay freeze continues beyond the 2024 presidential August 3rd, 2010 memorandum free of the discretionary award bonuses similar payments of the political appointments continue in effect until further notice. The agency shall continue to apply with the freeze until further notice according to the Office of Personnel Management and Guidance. Basic salary level executive schedule with section 5311 through 5318 with the Title 5 United States script prescribes salary with a position filled with the presidential appointment at level 1 through 5 with the executive schedule of 2024 with the executive salary range from the 180,000 level 5 to 246 and 400 to level 1. Executive schedule officials that do not receive the locality pay with their pay rate with the subject to pay free for the certain senior of the political official section 2 of the Presidential Appointment Efficiency Streamlining Act of 2011, Public Law 166 August 10, 2012, remove the Senate confirmation requirement that certain presidential appointment position in the number of agencies. Section 2HH provided the removal of the Senate confirmation requirement under Section 2 but it would not result in the 1, any of the such position being played for the senior executive server the 2 with altered compensation for any such position under executive schedule for the other applicable compensation provisions of the law. Senior executive server the agencies have the name of the may set the shareholder of the member of senior executive services. At the rate with the range fixed with the statute maximum senior executive server the rate with the rate of the level of 2 and 3 with the executive schedule with the higher level of 2 maximum applicable to only senior executive server the position covered with the certified senior executive server the performance appraisal system. In 2012, the senior executive basic salary may range from the minimum rate with a $147,649 maximum rate of $204,000 or $221,900 for senior executive position covered with the certified senior executive server the performance appraisal system. Senior executive server the members do not receive the locality pay. Certain non-career senior executive service members may be subject to have pay free with a certain political official for the generally seniors. All seniors, any senior service member may receive the pay adjustment only with once during a 12-month period. Senior level position, senior level pay system with the Title 5 U.S. Standard Code 5376 for the apply with both the senior level position established in Title 5 U.S. Standard Code 5108 scientific professional position with established under Title 5 U.S. Standard Code 3104. These include the high level position executive responsibility as well as the position of law of the presidential exclude from the senior executive server the agency have set by the senior level or senior scientific professional employee with a range fixed by statute. In the 2024 basic salaries may range from the minimum rate of $147,649 maximum rate $204,221,900 for SL or ST position covered by certified performance appraisal systems. SL and ST employment that do not receive the locality pay off the permanent personal management. Contact Daniel Oplica 202-606-2076 for the general schedule. The general scope of the pay system has a 15 grade level of 10 salary step with each for the grade maximum rate with the basic pay with the 2024 $159,955 GS 15 step 10 exclude locality pay June 2020 the additional locality payment for the employee with the United States with the territory with the possession range of 16.82% to 45.41%. No locality adjusted may be exceeded the rate of level 4 with the excluded executive schedule with $191,900 in 2024. New GS general schedule. The employees generally enter for the first step of the appropriate grade with the most schedule. The employees are under the general schedule pay system. Special pay authorities around 22% of the federal government. 1.9 million white-collar workers are not paid with the general schedule, but are paid under the other statutory authorities. For example, Administration, Federal Aviation Administration may set with the pay with the Federal Administration employees, aviation employees. The President may set with the pay with the certain White House employees. Locality pay. Most of the white-collar federal employees include with the general schedule. Employees must exclude with the most of the service senior executive services members but not listed as senior level or senior technical employees. All executive schedule officials are the eligible supplemental locality basis payments for the additional rate of the basic pay. These base payments apply on the United States with the territory of the position. In 2024, locality payments range from the 16.82 to 45.41%. Maximum locality adjusted rate of the general schedule employees rate of the the executive schedule level of 4 with the $191,900 in 2024. No, under separate legal authority, some of the employees working with the overseas may either supplemented salary, supplemented made amount, but is based on the general schedule of the locality rate. Aggregated premium pay for the limitation. Most federal employees are subject to the annual aggregated pay limitation under Title 5 U.S. Standard Code 5307 with the restrict the total amount of the pay employee that may receive at any of the calendar year pay, and except for the limitation payable at the beginning of the next calendar year. Counts to the next year is limited for the senior executive service members of the senior level and senior technicians. Employees are covered with the certified performance appraisal system with the aggregated pay limit at the annual rate with the pay with the vice president $284,600 in 2024. For all others, the aggregated pay limit at the annual rate pay of level 1 executive schedule with the 246 of the 400 in 2012 with the Title 5 CFR Part 530 for the Subpart B. In addition, the general schedule of the employee with the other covered employee with may receive a certain type of the premium pay with under the Title 5, including overtime payment and employee with except the federal labor say there's Act Sunday pay with the night pay with the holiday pay with the biweekly pay period with only with the extent of the sum of the basic pay with the premium pay for the pay period that does not exceed the greater than a biweekly rate payment of payable for 1 GS 15 step of the 10 with including applicable locality payment, a special rate of supplement, 2 with the rate of pay with level 5 with the executive schedule with the C Title 5 U.S. Standard Code 5547A in the Title 5 CFR 550105. Certain emergency mission critical situation, any of the agency may apply with the annual premium pay for the cap instead of the biweekly premium pay cap. Except for the condition provided law and regulation Title 5 U.S. Standard Code 5547B for the Title 5 CFR 550106, 55017, the basic guidelines for the overtime pay with the compensatory time off of the Schedule C employees over the personal management memo, overtime pay with the compensatory time off of the Schedule C employees. Play flexibility. Agency may even the number of discretionary for the play flexibility to deal with the well-documented staffing difficulties, special statutory and regulatory conditions governing with the use of each of the flexibility. Each agency justification documentation will require the agency show the extra of the flexibility judicial, especially when other than career employee with the payments of the subject of the public scrutiny with the third party review, but these should be used only the necessary to address the document staffing problems given in the current official environment. The agency should monitor the use of the compensation flexibility so they are all used in accordance with the budgetary limitations. Advance payment. The agent provide with the advance payment of basic pay, with including any locality payment covered no more than 2 pay periods of the individual who is newly appointed with the position. Some in an agency have Title 5 Part 550 Subpart B. Above minimum hiring rates, general schedule. The agency must pay with the individual newly appointed general schedule position step above the first step of the grade based on the employee supervisor superior qualification. Special need agency for the employee. So for the agency may use flexibility in any appropriate GS grade. With the agency may set with the pay with a higher set of the initial unemployment upon reappointment after the 90-day break with ensure the agency may not be set based on the judicial job candidate with a non-federal salary history of the based on the salary and competing job offer Title 5 531 212. Pre-employment interviews of the payment of travel to transportation expenses. The agency may pay the travel to transportation expense for the travel to firm with the pre-employment interview with the individual with the concern of the further employment travel expense with the attend with the confirmation hearing with the concern of the part of the pre-employment interview proper. The agency also may have the travel expense with the new employment firm with his or her place residence for the time and selection with the assignment of the duty station Title 5 Part 572 for the recruitment and relocation. Some of the agencies have the authority to pay with the recruitment and relocation. Some of the agencies may not pay with the recruitment, relocation, and some of the employment in a position to which the individual was appointed by the person of the senior executive service as a non-career appointment, which had been expected with the competitive service of the region with a confidential policy, determining policy making with the policy, advocating character of the Schedule C with the designated the head of the agency, including the agency head of the collegial body with the 2 or more individual members in which the employee would expect with the receiver the employment as the head of the agency and with a senior executive with limited to determine appointment with a limited emergency appointment when with the appointment must be clear with the White House official or with the presidential personnel. The agency may pay for the recruitment incentive to employ with the newly hired federal government with the relocation incentive of the new employee who must relocate to fill the position, otherwise it is difficult to fill. In return, the employee must sign an agreement to complete with a period of service within the agency 6 months of the minimum period of the recruitment incentive of the total amount of the recruitment and relocation incentive of the payment may not exceed 25% of the annual rate of the basic pay of the employee with the beginning of the service period, with it multiplied with the number of years and service period of the personal management approval cap at the beginning rate with 50% based on the critical agency needed. As long as the total said that does not exceed 100% of the employee's annual rate of the basic pay with the beginning of the service period, the agency may pay with the recruitment of the relocation sum of the initial lump sum of the payment at the beginning of the service period with an equal variable and sum of the payment through the service board, the final lump sum of the payment upon the completion of the service board period. Combination of these methods, the agencies may pay recruitment and relocation sum of the eligible employees under the general schedule of the senior executive service of the senior level pay system, certain other pay systems, recruitment and relocation sum of the subject to aggregated limitation on total pay that the employee may receive within the calendar year. Title 5, Part 575, subparts A and B, aggregated premium pay limitation sections above. Retention incentives. The agency may also pay with the retention and some of the bonus payments for the same categories of employees who are excluded for the receiving the recruitment and relocation incentive that are barred from receiving the retention incentive. Agencies may pay the incentive to current with the employee if the agency determined the usually high on unique qualification of the employee with a special agency need the employee service to make it essential to retain the employee if he or she would likely to leave the federal government for any reason, including the retirement, absent retention incentive, or agency has a special need employee services that makes it essential for the retaining the employee with his or her current position during the period of the time before the close of relocation of the employee's off of the facility, the activity, or organization of the employee would be likely to leave different position federal service in the absence of the retention incentive. An agency must establish a single retention incentive of the rate with each individual group of the employee with expressed the percentage of each of the employees' rate with the basic pay with not to exceed 25% of the individual employment, 10% of the group of the category of the employee. Off of the personal management approval, this capital can be increased as much as 50%. An agency may pay the retention of the pay as retention and incentive and so much after the completion of specific period of the service and single lump sum of the after the completion of full period service required by the service agreement. Agencies may pay retention and some of the eligible employees' general schedule, certain or executive service at the senior level pay system, certain other pay systems. Retention incentives are also subject to aggregated limitation total pay that an employee may receive in the calendar year. Title 5 CFR Part 575 Subpart C, aggregated premium pay limitation. Special rates. Off of the personal management may establish a higher rate of the basic pay for the group of the category of general schedule positions in one or more of the geographical area. The specific rate of the authority is used to address likely significant difficulties recruiting and retaining well-qualified employees. Over the personal management may establish special rate of the occupational series, specialty grade level of the geographical area. Special rates of the supplement are applied with the basic general schedule, and no special rate of the established excess for the rate of the basic pay with the level of 4 executive schedule. Title 5 U.S. Standard Code 535. Title 5 U.S. Standard Code 5305 and Title 5 CFR Part 530 Subpart C. Over the program management, contact Mark Allen 202-606-2858. Critical position pay with the agencies have with the request off of the personal management consult with the office of management of the budget grant or authority of the first of the fix of the basic with the rate with one or more positions higher with the rate would authorize the payable for the position of the consideration must require the extremely high level of expertise for the scientific, technical, professional, administrative field with the critical with the accomplishment and important agency mission. Up to 800 positions may be covered with the government while the authority allows up the setting of the paying of the rate of level 2 of the executive schedule, level 1 executive schedule if the agency demonstrates exemptional circumstances for the greater than the rate of level 1 for the executive schedule in rare circumstances. Title 5 U.S. Standard Code 5377, Title 5 CFR Part 535. Operational OPM, contact Mark Allen 202-606-2858. Student loan repayments. For most type of the employee of the agency may establish the program under which they may repay with a certain type of the federal made with the insured with a guarantee with the student loans over the incentive of the recruit with the retain highly qualified personnel under the agency to make a loan payment to loan holder up to $10,000 for the employee in the calendar year with the aggregated maximum of the $60,000 for any one employee. In the return of the employee must sign with a service agreement that remains service of the paying agency for the period of at least 3 years. If the employee separates the voluntary, separated involuntary for the cover of the poor performance before fulfilling the service agreement, then she should reimburse for the paying agency for all the student loan repayment benefits received. The agency may not provide student loan repayment benefits to an employee with the occupying a position except with a competitive service because of its confidential policy, determining policy, making policy, advocating chart. Character, Schedule C, appointments, Title 5, CFR, Part 537, Office PMN, Jennifer Melvin, 202-606-2858. Reemployed annuities. Office of Personal Management, contact Michael Glenn, 202-606-0960, and most give the federal retire with the company civil service retirement, serve with the federal employment, the retirement system, reemployed with the federal service, they continue to receive the annuities, salaries, officer with the amount of their annuities. Title 5, U.S. Standard Code 8344-8468, with the office supply with the retiree employees are appointed by the expert with the consult with the agencies may request the Office of Personal Management waive the offset with the requirement of limited circumstances without the statute of PM regulations, Title 5 CFR Part 55, 3 in additional Section 110007, National Defense Authorization Act with official year of the 2015 amended with the provide with the authority head of the agency for the grant salary offset with the dual compensation waiver the temporary basis for the under specified circumstances without Office of Management approval through December 31st, 2024. Federal retire with the return of the work under the appointment of the Department of Defense to continue with the pursuit of these annuities, pursue with the full salaries without offset or in certain circumstances due to the retiree's return of the work for the Department of Defense may elect to have their salaries offset with the amount there of the annuities for the attainment of the higher retirement benefits after the reemployment ends. CSRS annuity with employee with the CSRS retired with the presidential appointment of terminated reemployment. The payment of CSRS annuities is suspended with a reemployed member of Congress. Employees shall consult with the Human Resource Office in their employing agency for further leave and further information leave. In the general office of the employees who are appointed with the presidential appointment staff and presidential appointment that are not covered by the federal leave, presidential appointed Senate and presidential appointed are not covered by the federal leave system that's established in Title 5 U.S. Code Chapter 630.3 if their rate with the basic equal to the exceed of the rate of level 5 of the schedule with the Title 5 630 to 11 and A3. These presidential appointments do not earn annual sick leave that cannot be charged leave of the absent over the work. However, the members of the senior executive service of the employee senior level, the scientific professional with the position are covered with the federal leave system, and even if they are appointed by the president of the career of the senior executive service members of who are accepted of the presidential appointment without breaking in service position outside of the senior executive service at the rate of the basic pay equal to the higher than level 5 executive schedule can elect to retain the senior executive service leave benefit continue to earn leave while serving the presidential appointment. Title 5 U.S. Standard Code 3392C1 under the Title 5 U.S. Standard Code 6301211 and Title 5 CFR 6302111 agency heads may exclude a presidential appointment from coverage under the leaving system under certain conditions. Okay, annual leave. General employee that earn 13, 20, or 26 days of the annual leave per year, depending on the years for the employee with the regular time of the work schedule. This means with the incremented accrement of 4, 6, 8 hours annual leave of each bi-weekly every pay period with any extra accrual of 4 hours last period of the year for the employee with a 6-hour accrual category. Annual leave. General employees earn 13, 20, 26 annual leave period depending on the years for the employee with a regular full-time work schedule. This means increment accrual of the 4, 6, 8 hours of the annual leave bi-weekly every pay period with the actual accrual of 4 hours last period with the year's employee with a 6-hour accrual category. However, the senior executive services members and the SL and ST employees, certain with the employee with a position deemed by the Office of Personal Management, with the senior service executive CSL or ST positions who have regular full-time work schedule with a crew with the 8 hours annual leave each bi-weekly pay period regardless of senior executive service members as well as the senior level of senior technician employees employed with the position of designated with an Title in U.S. Standard Code 1607A. As intelligence senior level position may cover up to 90 days of the annual leave of the next leave year, and most of the other employees may cover up to the 30-day annual leave of the supervisor may with granted advance of the annual leave at his or her discretion consistent with the agency's leave policy. This amount of the annual leave of the may advance may not exceed the amount of the annual leave of the employee will accrue for the remainder of the leave year of Title 5 U.S. Standard Code 6302, 6304, Title 5 CFR Part 630, Subpart B and C. No, under certain circumstances, the agency may give the newly appointed employee with the employee who is the reappointed following the break-in service at least 90 calendar day with the credit of the qualifying non-federal service experience of uniform service and determine the employee's rate annual leave of the accrual of the head of the agency with his or her designated must determine the individual skills experience of the assessment for the new position that will be required through the performance in non-federal uniform service position with having the duties directly related to the position which for he or she with the being appointed for that use the authority to the necessary to achieve an important agency mission for the performance goal determined must be made with the priority employee's entry on duty. Title 5 U.S. Standard Code 63003E with the Title 5 CF 6300205. Sick leave employees earn 13 days sick leave if they accumulate without limited to the exceeding year for the full regular time. Employee sick leave accrues incrementally rate of 4 years each for the bi-week pay with a sick leave of the base of paying absence of the employee with intel for the use of the personal medic for the general family care purposes. Care of family member with a serious health condition, adoption related for the purposes of bereavement for the care of the covered for the members with a series of the areas, injuries, illnesses provided with the employee invoked his or entitlement to leave under the Family Medical Leave Act. There is no limitation of the amount of sick leave that the employee can use his or her of the other personal medical needs of the adoption related to purpose of the employee may use up to 12 weeks, 480 hours sick leave at each year leave year to care for the family member's serious health condition, which include 13 days, 104 hours sick leave for general family care bereavement purposes. Employees entitled to not more than combined total 12 weeks sick leave each leave year for all family care purposes. Sick leave may advance for the discretion agency consistent with the agency policy. Agencies may advance up to 30 days, 240 hours sick leave to an employee purposes, including employee with a family member's serious health condition, adoption related to purpose of care for the covered service members with a serious injury or illness, provided with the employee invokes his or her entitlement. Family Medical Leave Act of the leave of the agency that may advance up to 13 days, 104 hours sick leave with an employee with employee's family member general medical needs to certain other purposes, including bereavement, the Title 5 U.S. Code 6307, the Title 5 CR 630 subpart B and D. Family and medical leave under the Federal Medical Leave Act of 1993 for the employees entitled to the total 12 work weeks unpaid level during the 12-month period of the birth of the child, the care of the newborn, placement of the child with the employee with adoption, foster care with the care of the employee's spouse, the child with the daughter parent with a serious health condition. Employee owns a serious health condition that makes him or her unable to perform the duty of his or her position, qualifying exigency of the rising out of the fact responsible for the son with the daughter of the parent employee with not covered active of the duty has been notified in impending call order of the active the duty of the armed forces. Employees who are familiar with the service member with a serious injury with an illness that should be incurred line of duty while the active the duty of the armed forces who are providing care for the service members entitled up to 26 weeks with the family medical leave of the military family leave during a single 12-month period of the care service member during the single 12-month period. The employees entitled to combined with a total of 26 weeks regular with the Federal Medical Leave Act of Military Family Leave. Employer may substitute annual leave, sick leave in advance in annual sick leave and then denoted to annual leave under this level levy sharing programs consistent with the current law of the Office of Personnel Management Regulations, such as leave, unpaid leave under the Family Medical Leave Act. Employees must have 12 months of qualifying federal civilian military service, which need not have to be continued with recent months to qualify the Federal Medical Leave Act leave. Paid parent leave with an employee with a qualifying birth or replacement, adoption, foster care with entitled with up to 12 with administrative work for the weeks for the paid parent rental leave, which may be the substitute for the unpaid leave that take from the Family Medical Leave Act of the personal paid parent rental leave that may only be used during the 12-month period for the filing of the birth or replacement involved thereafter, which is unused the personal paid parental leave will be forfeited to an employee that may receive the lump sum of the payment of the unused the forfeited personal paid parental leave under any circumstance the leave may not be saved for the use of the future birth or replacement. Agency may require the employee to provide appropriate documentation showing the employee use the personal paid parental leave with the documentation connected with the birth or replacement of the occurred with the responsible to determine the documentation sufficient proof of the entitlement before an employee with them receive paid parental leave. The employee must agree with the writing into work at least 12 weeks for the employing agency employee with the employees with the day with the using of the paid parental leave that includes the failure to complete with a 12-week or obligation may result in the employee being required for the reimbursement of the agency for the employee with the employee during the leave of the paid parental leave with the determination of the reimbursement of the agency solely exclusive of the discretion on the lease of the waiver that is required with the state of the regulation. The reimbursement equals the total amount of any of the government contribution agency paid with the maintaining the employment health insurance coverage over the federal employees' health benefit programs during the period of the paid parental leave was used. Parental bereavement leave with an eligible employee within the 2 work weeks paid for the leave for the purpose of the bereavement in connection with the death of the employee's qualified child under during the employee's federal service. Parental bereavement leaves must be used within the 12-month period following the child's death. The qualifying child may be biological, adopted, foster kid, stepchild, legal, warded, a child from whom the employee is standing in local parentis. A qualified child must be under 18 years of age. For the older the age for the inactive self-care because of a mental or physical disability. Employment arrangement eligibility requirements include 1, having a full-time, part-time work schedule that is not intermittent, 2, having a non-temporary appointment. This appointment is not limited to 1 year or less, having completed 12 months of the qualifying federal civilian service, the military service, leave of the transfer, leave of the bank programs. Any employee has personal or family medical emergency that exhausted his or her own paid leave that may be received with the donated with the annual leave from the other federal employment with the voluntary leave transfer program, the voluntary leave of the bank program. All agencies must leave the transfer program. In addition, the agency strongly encourages to establish a leave of the bank program for the employees. There is no limited amount of the donated annual leave of the leave of the recipient may receive at the terminal level. Leave of the donor's agency leave bank. However, the unused donate leave of the must return of the leave donors and agency leave bank as the applicable with the medical emergency ends. The employee may participate concurrent within both the VLTP or VLBP and available if available in Title 5 U.S. Standard Code 63 subchapters 3 and 4. Title 5 CFR Part 630, Subpart I and J, leave and the transfer of the combat-related disability. Employee with the sustain of the combat-related disability serve with the members of the armed force, include the preserve component of the undergoing medical with the treatment of the disabled, the receive the donated annual leave of the other federal employees through voluntary leave transfer program that have exhausted his or her available to paid leave of the qualified leave recipient and eligible to receive the donated annual leave of up to 5 years from the start of the employee treatment, as long as the employee continue to undergo such medical treatment. Title 5 U.S. Standard Code 63, Subchapter 3. Emergency leave transfer program in the event of a major disaster emergency that's declared by the President with the result of the reverse adverse effects for the substantial number of the federal employees. OPM and the consolidation of the personal management budget may establish emergency leave transfer program and emergency leave transfer program employee with the executive judicial branch of the agency level banks, levy banks may donate annual leave to the employee with the same of the other agency judicial branches are adversely affected. Have the family members of the adversely affected of the disaster, emergency flood, earthquakes, hurricanes, bomb, and the other emergency leave transfer programs established by the agency with effect for the employees administrative of the program for their employees. Disabled veteran leave of the employee who is a veteran with the control of connected with a disability rating of 30% of the more of the veteran benefit administered with the Department of Veteran Affairs until with the 104 hours of the disabled veteran leave of the purpose of the undergoing medical treatment associated with the disability. Disabled veteran leave of the one-time benefit to provide with the eligible employee. The employee is signaled with a continuous 12-month eligibility period beginning with the first day of the employment is of the term defined with the regulation which those leave will be forfeited in Title 5 U.S. Standard Code 6329, Title 5 CFR Part 630, Subpart M. Military leave. The employee who is appointed with is not limited to last 1 year and until the military leave with the full time of the full pay of the certain activity and active duty with the National Guard, with the Reserve, of the Armed Forces. 2 types of military leave are the most common. The first employee with until with a 15-day with the military leave per official year with the active duty training, and active duty training, the funeral honors duties. Up to 15 days may be carried over in the next fiscal year. Second employee with until with a 22 days work of leave with a per calendar year for emergency duty as ordered by the President, Secretary of Defense, State Governor, with the employee perform the military duties support with the civil authority protection of life and property and the perform the full-time military support the result of the call in order to active duty and supporting contingency operation defined in Section 101A13 Title 10 United States Code. For 22 days with the military leave of the employee's civilian pay is reduced by the amount of military pay with the day with the military leave. Note that 22 days may be carried over the next calendar year. Court leave of the employee with until with a paid time off without charge for leave of the service of the juror of the witness judicial proceeding with the federal, state, and local government is in party. Leave of the bone marrow organ donors employed with an entitled 7-day period over each of the calendar years to serve as a bone marrow donor, 30 days each calendar year for the organ donor. More information, additional information, federal government leave programs included described above is of the OPM website. Separation payment is certain payments that may be applied payable to individuals separated from the federal service. Severance pay. Severance pay is authorized for full-time and part-time employees for the involuntary separated with the federal service who meet the other conditions eligibility to be eligible to serve. Severance pay with the employee must be serving under the qualifying employment, have completed at least 12 months with continuous service to be removed from the federal service, involuntary for the reason of the misconducted unacceptable performance, presidential appointment, and expected employment under Schedule C, non-career appointment in the senior executive service is defined in Title 5 U.S. Standard Code 3132A with equivalent employment that may be the similar purpose of the not qualifying appointment. Therefore, individuals serving under those employments is not eligible for severance pay. Title 5 U.S. Standard Code 5595, Title 5 CFR 550, Subpart G, careers of a senior executive service appointments who accept the presidential appointments may elect to retain severance pay and benefits in the Title 5 U.S. Standard Code 3392C with the Title 5 CFR Part 317, Subpart H. Alright, lump sum payments used unused annual leave, and I'm waiting for... We'll cut the tape there.